they may just be seated there, it's fine.
It's regarding my learned colleague, which is representing accused number 1.
Okay, just hold on. People are taking pictures and they
Yes.
haven't been given the
Exactly.
permission to do so yet.
So I request for the accused to be excused until this housekeeping issue is sorted out. Your Worship.
So, all right, we'll call the matter in a few minutes. Perhaps at this stage I could say the recording is not to continue at this stage. Let's just deal with your
Thank you. So in
I've seen the application that's
correct, Your Worship, it's for the media actually to broadcast and report on the matter, and I'll hand over to my learned colleague, Mr. Kruger, who's representing that is accused number 1 in this matter. I believe it's only 10. I've spoken to the other legal representatives. That is Mr. Makola for accused number 3 and Mr. Lebete for accused number 4. And we just need to confirm our order as well, Your Worship, since you have them in the box. So we don't have an issue. May I hand over the charge sheet accordingly, Your Worship?
okay, there are 3 accused now.
Yes, Your Worship.
Told me yesterday there were 3 and 4.
Accused number 1, Mr. Ndlovu. Accused number 2, accused number 3, Your Worship, is actually Mr. Rodney Muchari, and accused number 4 is...
I'm not going to bind the trial court to my decision to continue to.
Worship, we are instructions are to proceed.
Thank you.
Thank you. As the court pleases in respect of that ruling, may I indicate to the court that this is actually an application to be held in terms of Schedule 5 with regards to charges that are being preferred against all the accused before court. The onus is then on them, all 3 accused, to actually move an application for bail and request the court to release them on bail. And with regards to the matter further in respect of bail, I may just indicate it's now for accused 1's legal representative, if they may begin, to address the court in respect of their application and what they may be for.
All right. We agree that it's a Schedule 5 bail application.
And the court pleases, Your Worship, with our instructions and included in an affidavit that we have prepared and has been signed by accused number 1. Your Worship, it is the request that we present evidence by way of affidavit. It has been deposed to by accused number 1. Your Worship, whereas it is 2:20, I can read it into the record because it so pleases the court.
Yes. Just before you do that, Mr. Ndlovu, court must inform you, sir, that your legal representative has indicated that he's going to make an application for bail on your behalf. He has an affidavit that has been prepared. He's going to read out that affidavit. Court must inform you that any evidence that you adduce in the bail proceedings, whether they are by way of an affidavit or whether you give oral evidence, any evidence that you adduce in these bail proceedings may be used in the main trial against you. Do you understand that?
Yes.
So listen carefully to what your lawyer reads out into the record. I might ask you questions about what he has read. Do you understand?
Yes, the court.
Do you want to use an interpreter or will you speak in English?
I'll be fine with English.
Thank you. And the other accused, do they require interpreters before we proceed?
No, Your Worship.
No, Your Worship.
Thank you. May continue, Mr. Kruger.
The court pleases, Your Worship. This is an application by the first accused for bail in terms of Section 6011B of the Criminal Procedure Act 51 of 1977. As stated earlier, the accused has deposed to an affidavit evidence that will be presented as evidence to the court in support of his application and to convince this court that it is in the interest of justice that he be released on bail. Your Worship, it is an affidavit by Dumakude, Ndlovu, an adult male South African citizen, and to which we have attached a copy of his identity document. Currently resides Unit 2255 Calvin Place, Sandown, Johannesburg, and the facts deposed in this affidavit are within our personal knowledge and true and correct. I have been informed that I will be charged with the crimes of the following: common law offences, fraud, any offence involving dishonesty, any other offence that the Commission proved by reason of the essential elements of the offence is being included in the above-mentioned offences, any other common law offences that are not known at the date of the authorization. This is the authorization of the search warrants, the attempt or conspiracy to commit any of the above offences. The statutory offences, including but not limited to contraventions of the following sections of the Tax Administration Act, Act 28 of 2011, sections 2351A and D, 235 sub 2, 2352D, section 23 of the Value Added Tax Act. Any other statutory offences involving dishonesty, any other offence the Commission has proven by reason of the essential elements that offences included in the above-mentioned offences. Attempt or conspiracy to commit the above-mentioned offences in terms of the Tax Administration Act or the Value Added Tax Act. This affidavit is in support of an application for my release on bail pending the criminal charges that have been brought against me in the circumstances set out below. I respectfully submit that I will endeavour to demonstrate here that the interest of justice allow that I be released on bail. I respectfully submit that the dictates of fairness and justice in view of the particular facts here warrant that I should not be deprived of my liberty and that I should be granted bail. To the extent that I make legal submissions here, and I rely on the advice of my legal advisors, which advice I accept as and believe to be correct. I'm advised that the present alleged crimes of fraud in an amount exceeding 500,000 rand is an offence which is listed in Schedule 5 of the Criminal Procedure Act. In terms of the provisions, Section 6011B of that Act, I am required, having been given a reasonable opportunity to do so, to use evidence which on the balance of probability satisfies the above honourable court that the interests of justice permit my release from custody. The alleged crimes have not been formally presented with a charge sheet or charges to be referred against me. Therefore, I do not know the exact nature of the charges to be preferred against me. This was drafted late yesterday afternoon. As we have said earlier, we have been provided with a draft charge sheet. I've not yet had access to the content of the case docket and do not know what, if any, factual allegations are contained there. I have, however, been informed by the investigating officer that I have been arrested for and will be charged with crimes referred to in paragraphs 5 and 6 above this affidavit. I deny that I'm guilty of any of these crimes or any of the allegations made against me. I have been advised that I have the right to remain silent and I'm not obliged to disclose the basis of my defence at this stage. I was in Durban, KwaZulu-Natal at approximately 6:30 on 30 September 2024 when I was contacted telephonically by the investigating officer informing me of the execution of the search, access and seizure warrant issued in terms of Section 29 of the Cyber Crimes Act and the search warrant issued in terms of Section 29 of the National Prosecuting Authority Act. I was also requested to report to the police station immediately. I immediately made arrangements to drive back to Gauteng, but on being made aware of the risk of the adverse weather conditions expected en route, decided to book an aeroplane ticket back. I was able to depart King Shaka International Airport on a flight at 12:45. Upon arriving at our Tambo International Airport, arranged for an e-hailing service to take me to Blackburn Downs Police Station to meet the investigating officer. I arrived there approximately 15:40. I have provided my fullest cooperation with the state and the investigating officer. In an attempt to assist the Honourable Court to arrive at a fair and just decision in this application, I have elected to place the following facts and factors regarding the alleged crime before this Court. To my best of my knowledge, all income received or accrued to me has been declared in all my personal income tax returns that are due and have been submitted to the South African Revenue Service. I am aware that SARS has raised assessments for the 2019, 21 and 22 years of assessment. As a result of the assessment, I owe SARS an amount, including interest, of 234,261 rand and 68 cents, which I have been advised is due to me receiving a travel allowance and not providing SARS with a logbook supporting the fact that I use my own motor vehicle for business purposes. These assessments are disputed and my representatives have been in communication with SARS from earlier this year trying to resolve the issue. I will be submitting a notice of objection and application for the suspension of the disputed tax debt pending the finalisation of the dispute shortly. Save for the foregoing above, I am tax compliant. I attach a copy of the income tax statement of account issued by SARS dated 30 September 2024, reflecting the current status and amount outstanding. As far as Amber Bride is concerned, it was managed at the time of the alleged offences by a certain Mandla Sitoli, who had full control of the data of management, bank account and financial transactions, and therefore I have no knowledge of these allegations. I have, however, instructed my attorneys to investigate the alleged charges against me and the company. With respect to personal circumstances, I am currently 69 years old. I'm currently married to Patricia Zaneke Ndlovu. I have 6 children. Your Worship,
It's not necessary to read out their names.
I currently reside at Unit 2255 Carlman Place, Sandown, Johannesburg. And with respect to Worship, I know that yesterday the investigating officer went to confirm the address. I'm not sure if my learned colleague has been advised of such confirmation. I am responsible for taking myself, my wife, and our minor child. One of the children is still a minor, Your Worship, and cater for the maintenance requirements and daily needs. I'm the sole breadwinner and provide for all the financial needs of my family. My continued incarceration will have a devastating financial impact on each of the above-named persons. I am currently a television producer and director of Word of Mouth Pictures and Rhythm World Productions. I, through the above companies, have produced award-winning television productions for the SABC, amongst others the SABC and MultiChoice, such as Ndlovu, which first aired in 1997 and continues to this day. In Bearwood, The Seed, Uzalo, which first aired in 2015 and is the most watched television program in South Africa of all time. And Queen Majaji, a series of 12 episodes that premiered on the 14th of July 2024. Whereas I am the sole director of Word of Mouth, it is solely dependent on my management and direction of the production of the current television productions and employees, both contracted and permanent, that number 800 to 1,000 at any one time. As an aside, in May 2011 I received an honorary PhD from the University of Venda. In May 2022 I was awarded a PhD by the University of Zululand Faculty of Humanities and Social Sciences. Worship, I have one immovable property registered in my name of 558 Kensington, Johannesburg, Gauteng, which was purchased in 1996. I am able to pay bail in an amount to be considered by the above honourable court as envisaged in section 60(12) and accept that the honourable court will impose an amount which is appropriate in the circumstances. Bishop, I now turn to deal with the statutory requirements as set out in section 60 of the Criminal Procedure Act. 61A, Bishop, I'm not sure it's necessary to go through all of these. It is why we say that it is not really specific to the accused, but it is an assurance that there's no likelihood of the accused contravening any of those sections and in fact complying with any of those that he is expected to do.
It's not necessary to read out each of the sections, but if you have the personal information that you want to attach to those sections, you may do so.
There's no likelihood that if I released on bail, I will attempt to evade my trial. I have significant assets within the Republic of South Africa, both of a personal and proprietary nature. I'm very committed to and close to my family. I will not intimidate any state witnesses or conceal or destroy evidence. I undertake not to contact, influence, or intimidate any witness to the extent necessary or applicable. There is no prospect that I will undermine or jeopardize the objectives or the proper function of the criminal justice system, and neither the bail system. There is no question that I will be a risk to the public order, to undermine the public peace or security if I am released. I understand that the offence with which I am charged does not relate to an alleged act of violence. I have strong emotional, family and community ties in the Republic of South Africa, as demonstrated above. I have also strong occupational ties within the Republic of South Africa due to the nature of my work. My assets and livelihood are all in the Republic of South Africa. I have a valid South African passport. I have travelled out to the Republic of South Africa on numerous occasions, but have always returned since the Republic of South Africa is my home. I am able to pay the bail amount considered by the Honourable Court and accept that the Honourable Court will impose an amount that is appropriate under the circumstances. I will not flee the Republic of South Africa and not attempt to evade my trial. Although I accept that the charges are serious, I reiterate that there is no need for me to attempt to evade justice, and with respect to which this has been demonstrated by the accused as recently as yesterday. I am unaware of the strength of the state's case. I respectfully submit that no likelihood that if released on bail I will attempt to evade my trial. Even if I were convicted, I am unaware of the nature and the gravity of the punishment which may be imposed on me, and I reiterate that there is no need for me to attempt to evade justice. Argument will be presented that no unduly onerous bail conditions need to be imposed upon me. I repeat, undertaking not to contact any of the state witnesses without my attorney's first contacting the state. It will be a simple matter to monitor whether this condition is breached. I am not familiar with any witness that the state may call. As far as I'm aware, no witnesses have made statements and have agreed to testify. As far as I'm aware, the investigation against me is in its initial stages. Whatever argument will be presented, that this is on its own is not a reason to refuse my bail application. As explained above, I'm not aware of any state witnesses which I may have a relationship with. Accordingly, they are not likely to be influenced or intimidated. Since the state will have been in a fairly regular contact with the witnesses, it will be relatively easy to monitor whether or not I am having any contact with witnesses outside undertaking which I have given. At this juncture, I do not have evidential material. There is no prospect of this evidential material being destroyed. I have not supplied any false information at the time of my arrest and during these bail proceedings. I'm not in custody of any other charge, and neither am I on parole. I've not failed to comply with any of the bail conditions imposed at any time, and there is every likelihood to believe that I will comply with the reasonable bail conditions that may be imposed on me. It is argued that under the circumstances of the case against me are not such that they are likely to induce a sense of shock or outrage to the community should I be granted bail. I sincerely believe that my safety will not be jeopardized if I am released. I am by no means a threat to society, and my release is not likely to lead to public disorder. Similarly, my release is not likely to undermine or jeopardize the public confidence in the criminal justice system. In terms of Section 11 Cap BA of the Criminal Procedure Act, I am advised that I am compelled to inform the court of the following. I advise that I have one previous criminal conviction. Approximately 20 to 25 years ago, I was convicted of a traffic offence and paid a fine of 50 Rand, 50. There are no charges pending against me, no order contemplated in terms of the Domestic Violence Act or the Protection from Harassment Act. At the time of the alleged commission of the offence, I was not a sentenced offender who had been placed under correctional supervision, day parole, or medical parole as contemplated in Section 73 of the Correctional Services, 68 cents, sorry. It also states that there are no outstanding returns. And that is for that reason why, save for the amount outstanding, which the accused is in discussion with SARS, is tax compliant. Your Worship, one would reflect if an amount was owing, if SARS had raised or should have raised assessment, if there is a case of fraud, or if the matters had not been preempted, that an amount of tax is due and payable upon the issue of an assessment. And currently, the amount, and I will not want to delve too much into it, Your Worship, this is based on the information that we have available. The amount due is
It's like weekly, but it's not really something that happens in reality on a weekly basis. And maybe we can just confirm that it could be maybe bi-weekly or once a month perhaps.
You're not opposed to a condition being imposed that he reports either to Santon or to Berea in Ndlovu.
No, there's no objection to that.
So then, if that condition remains, then what would be the purpose of asking for permission to travel? Because he's going to four is represented by Ms. Ndlovu. The respondent in the bail application is represented by Advocate Singh. Now the applicants or the accused were apprised of the provisions of Section 6011 of the Criminal Procedure Act.
Or the Republic, they need to inform the investigating officer accordingly of their travel plans. So I've just indicated the travel of 10,000 rands that we quoted as being involved with regards to accused number 3. Similarly, travel documents and the reporting condition, that officer accordingly. And with regards to accused number 1, who suggested an amount of 100,000, Your Worship, we have no issue with that amount as well. That they do have possible international relationships with amount suggested by the state be imposed and set as being requested and submitted by the state. And the fact that they all also share common directorship of some of the companies, and in view of the corrections before this court that I have placed, they have some of the accused distorted to a certain extent. Those are finally the state submissions, all 3 conditions as we suggested, as well as the amounts suggested by the state, which is suitable to all 3 legal representatives, the 11th of November. 11th.
I know it. 11 November to which court? Back to this court or to another court?
I believe it's this court until it's ready to be transferred, Your Worship. That's what we were informed. Then it's allocated.
Only have passport for case number 1.
Record, if the court will bear with me, and maybe the accused can confer.
The applicant number 1 travels or obtains permission to do that kind of travel because it's on a weekly basis?
Police stations. I don't feel it's onerous because I don't think it's really an issue in terms of his travels in reality on a weekly basis, and maybe
You're not opposed to a condition be that. So then if that's...
Yes, Your Worship, but sometimes in another province, by the time that's act, and my learned colleague has suggested that it wouldn't be onerous. I don't think it would also be very onerous on them to contact merely the investigating officer and advise them that we are now leaving KZN or going to his directorship on the various companies and his business relationships. So, but I've gone for travel, for example, to Cape Town, because he's leaving the province as such.
Mr. Kruger?
in Gauteng and in eThekwini. And the we suggest the onerous or the responsibility or was it administration or red tape that would cause an investigating officer to continuously entertain such reports. Your Worship, whether you report with respect to it is made aware of your bail conditions. Should he be travelling to another province or another country for that matter, Your Worship, that should be discussed with the investigating officer like it was argued on behalf of the accused, that it be in the discretion interaction or unnecessary interaction between accused and the investigating officer who does have other matters to investigate.
Have to report at 2 different police stations on which he is in Gauteng for sure.
Not necessarily, Your Worship. That has been canvassed. But should it, we will inform him, and then if we are in KZN or in eThekwini, we will report to a police station. But that would be what it will be. Court will set out the parameters of the bail conditions, and within those parameters, Your Worship, may I approach?
I'm just thinking about if I made it a condition that he reports either on a Monday or another, see to it
Yes,
that he's
Your
once
Worship.
a week report.
Executable, if I
Yes.
may say that. Thank you, Worship. Worship, the discussion with his travels and his plans to accommodate that so that he will be in Sandton at least one day of every week until the trial is available. I've sent a family member to collect it so that we can confirm the number as discussed earlier. But the suggestion is also that we deliver the passport to the investigating officer.
All right, thank you. And then Ms. Lebete. Not Mr. Makola. Want to ask about accused number 4. Want to ask Ms. Lebete about accused number 4. Prosecutor says that he travels regularly out of the country.
He normally takes the children to Zimbabwe during the school holidays. However, since you will be handing over the passport, he won't be able to.
Yes, Ms. Singh.
Yes, Your Worship. We are in possession of a movement register from the Department of Home Affairs.
It was in April or June, because during that time, it was during the school break, and he took kids for school break. That's why able to travel without the passport. Thank you, Your Worship.
Do you believe that? Believe that people can't travel without a passport in South Africa?
On Friday, you will report to the police station. How will he travel between Monday and Friday without reporting to police station? It will raise the flag if he doesn't report to the police station. If he needs to report 3 times, we won't have.
And the nearest police station is at Germans.
In view of the submissions, although we're not opposed to the fixing of bail, but I take exception to the submissions that are coming before this court. I mean, for example, his movement control, just alone in 2023, was July, March, October last year. Then we've got for this year, July as well, around March 2024. It's actually running into pages, Your Worship, in terms of his movement control. And I may just indicate his wife as well. And then sometimes they are together when they have an expired passport.
That's why I'm asking, do you believe that people can travel in and out of the country with or without a passport? It's meaningless.
Exactly. That's why I'm addressing court on these submissions.
Issued a new passport. He has a new passport which is not expired.
strict conditions as to how many days he can.
Is in contradiction with the evidence.
Your Worship, maybe if the court can
I'm
point
sorry, I'm
out
looking at-
what I'm saying in shortly. He has the one passport that is expired. He's going to submit that one also.
And you don't know the dates, when he applied and when he received a new passport, etc.
He stated that in January, but I don't know the exact date. I can confirm with him, Your Worship. Thank you.
I just want to know when it expired and when.
In
24.
January. Worship. Thank you, Worship.
And for accused number 3 is the police station Randburg.
May I please approach your Worship?
And he has no passport.
Passport has expired.
It's expired.
That's correct, Your Worship.
No valid passport.
No, when we were, Your Worship, reading our bail affidavit that we will.
All of these submissions in respect of travel and passport and issue, Madam accused number 1 has indicated they do have the passport in their possession, and others by tomorrow latest. You know, when we negotiated in this matter in good faith, Your Worship. And then we see these submissions now that are these submissions because it is after the bail. And in view of this, Your Worship, I would request then that the passports be handed in much earlier, Your Worship, in view of the movement.
All they need to apply to court and not to the investigating officer. Right, but in view of the fact that the prosecutor is not opposing the bail, I'll give you the decision on the bail application now. In the main action, they are accused 1, 3, 8 them. So I'll deal with all 3 the applications in one. Who were arrested on the 30th of September 2024 have brought Mr. Andre Kruger, applicant number 2, or accused number 3 is represented by Mr. Makola. The respondent in the bail application is represented by Advocate Singh. Now the applicants, that any evidence adduced at the bail hearing may ultimately be used in the main trial. It is common cause that the offences that the applicants are charged with fall within the ambit of Schedule 5, the provisions of Section 6011 of the Criminal Procedure Act 51 of 1977, Schedule 5, or a Schedule 6 offence. The onus rests upon that accused to satisfy the court that the interest to the applicant or from the respondents to the applicant to satisfy the court on a balance of probabilities that it would be in the interest of justice. Application is therefore, in terms of Section 60, subsection 2B, C, and 2A of the Criminal Procedure Act, expressly given B, subsection C of the Criminal Procedure Act, the accused evidence at a bail hearing in the form of an affidavit is also admissible at the trial. Authority that deals with the receiving of evidence in the form of an affidavit, but I don't think it's necessary for me to go into that at this stage. The provisions of Section 6011 of the Criminal Procedure Act places stringent conditions on a person charged with a Schedule 5 offence, in that the accused person charged with such an offence has to adduce evidence which satisfies the court that the interests of justice permit. A person charged with a Schedule 5 or a Schedule 6 offence, the acceptable norm is that those persons should be kept in custody unless they comply with Section 6 offences on the one hand and the interests of justice on the other. An accused person's personal circumstances in the case of Skittercut, 1998-2, SACR 707, the judge stated, bail proceedings are sui generis. The applicant investigated. The state is thus not obliged in its turn to produce evidence in the truly an opinion or a value judgment of what an uncertain future holds. In essence, future. Now, the applicant's case, each of the applicants repeat all the averments made in those affidavits. It has been dealt with in detail, their personal circumstances, whether they've traveled in and out of the country. We know that accused now in the country and outside of the country. He intends pleading not guilty to the charges. He says he's unaware of the witnesses for a traffic-related offence, and he has no other pending cases against him. Are employed. They have families within or in South Africa. Accused number 4 is a foreign national who has permanent persons have filed their applications in the form of an affidavit where they set out and they are all give their ability to pay the bail that may be imposed by this court. The respondent's case, or the respondent, the state in this matter, has not provided any evidence. The prosecutor or the advocate before the court has addressed the complete deal with determining the interests of justice, because even though the state is not opposed to the bail being granted for accused 1, 3, and 4, it is still in the discretion accused be released on bail. Now, in a practice between the liberty of the individual on the one hand, and the is expected to consider one issue only, and that is of justice, irrespective of the effect of such refusal on the individual accused. In striving to strike this balance between the interests of the accused and the interests of justice, Section 64 of the Criminal Procedure Act, the paramount considerations are, just as Mr. Kruger has placed before the court, conceal or destroy evidence, and whether the accused will commit offences while on bail. In assessing these risk factors, the court will in each time be faced with a number of additional considerations which may vary from case to case. Scrutiny by the court. The advocate for the respondent has pointed out where she felt there were discrepancies in respect of the travel movements of the accused, and she's also provided the movement of the accused may be monitored. The current charges, the applicants may be acquitted at the main trial, cannot be denied. This court is, however, not concerned with proving the guilt or innocence of the applicants. It only looks at pointers in the direction or to arrive at a decision as to whether it can be said that the accused. in view of what the advocate has placed before the court, there is sufficient evidence of active involvement of the applicants that has been placed before the court by the respondent to suggest that a prima facie case or in issues and pending cases that has already been mentioned by the applicants, and the court takes that into account. Court also takes into consideration whether or not the accused or the applicants herein may evade their trial. Section 60, subsection 4, subsection B of the Criminal Procedure Act provides that the interests of justice do not permit the release from detention of an accused where there is a likelihood that the accused, if he or she were released, it was held. The seriousness of the offence is a factor which a court must weigh in the balance. The risk of absconding and the likelihood that a non-custodial sentence might be imposed are factors which the court must also take into account. When the court considers this particular matter before the court, it is so that there may be, there is a likelihood of minimum sentences, factors that the court may consider whether or not they will evade their trial. All his interests are in the country. Accused number 3 and 4 have also placed their personal within the country, and they have strong ties, family ties within the country. Factors which the court must take into account when considering. The court has considered it, and the court also considers the possession of the travel documents that the accused have in their possessions and whether or not they will be able to. Court must also consider whether if the extent to which the accused can forfeit suggested to the court that the court may impose in respect of bail, and the respondent has also pointed by the applicants that they may pay as bail. Accused number 1 has indicated an amount and stated that he is in a position. In respect of 2 and 3, lesser amounts have been suggested, but the evidence or the arguments that have been placed before the court upon considering the amount if bail is fixed in that higher amount. Already dealt with the seriousness of the offence and the gravity of the punishment that may be imposed, and the binding effect of subsection J of section 60, subsection 6, which says any other factor which in the opinion of the court should be taken into account. Now we've heard that the accused number 4 has argued the overcrowding in prisons and that the accused should be released because that will be to if justice. Do not permit the release of a person on bail. It does not matter what the prison conditions are. That is a separate issue. If the court had to consider the overcrowded conditions and that they're not suitable for an accused person to be sent or to be detained in, then that would mean that all court proceedings must be halted completely. All court proceedings should be suspended, and courts should not have to do any more work until the prisons are able to address their so as to receive accused persons into those conditions. So the fact that there may be overcrowding in prison and that the prison conditions are not conducive, that is a separate issue to be considered by the correctional services and not by this court, as this court does not have to consider that accused release on bail. Enforcement officials, and that they have demonstrated their willingness to stand their trial. So bail is to facilitate minimal interference with an accused person's lawful. Having considered the evidence that has been placed before the court and the submissions made by the legal representatives on behalf of the applicants as well as the respondent, Advocate Singh's submissions on behalf of the respondents, I am persuaded that the interest of circumstances, the application to be released on bail is granted on the following conditions. Mr. Ndlovu, would you stand up, please, sir? In terms of sections money, the accused shall be released from custody on the following conditions: that he appears personally at the Johannesburg such dates and to such places to which these proceedings are adjourned until a verdict is given in respect of the charges to which the offence in this case relates. Condition number 2 is that the accused does not make any direct or indirect contact with any state witnesses. Condition number 3 is that the accused reports in person to the person in charge of the charge office at Sandton Police Station between 6 a.m. and 8 p.m., commencing on the first day after the accused's release on bail and every Monday or Wednesday thereafter. So once a week, either a Monday or a Wednesday, the accused must report to 5 Commonplace Sandown and 18 Clive Road, Berea, eThekwini, KZN. And if he should change such address, he will notify the clerk of the court in writing of such change within 24 hours of such change taking effect. That the accused is to hand in his passport, we do not know the number now, to the investigating officer, and that you are not to apply for another passport without the express permission of the investigator. To enable him, sorry, that's condition number 7, or number 6, that the accused makes an application to court for the release of his passport to enable him to travel outside of the borders of the Republic of South Africa whilst this case is still pending before. Ucharini. 7. Criminal Procedure Act. The accused is granted bail in the sum of 50,000 rand. Accused appears personally at the Johannesburg Specialised Commercial Crime Court, Court number 7, sitting here at Palm Ridge on the 11th of November 2024, and thereafter on the offence in this case relates. 2. That the accused does not to the person in charge of the charge on the first day after the accused's release on bail, and then every Monday thereafter. 4. That the accused's address is corner Eastwood Avenue and Blofalk Street, within 24 hours of such taking, if though he says the passport is expired 2024, and that he does not apply for another. To enable him to travel outside, those are your